All right. Hello, everybody. This is for business law, BADM 355. Basically, it's going to be chapter 12. The chapter is entitled Personal Property. The outline I have listed as personal property and bailments. So now what we have is we're moving into the area where we're going to be talking about personal property. Well, the very first thing that I have on the outline is a question there: personal property versus real property. And what's the difference? I think I have mentioned this to you a few times during the semester so far, that there are two great categories of property. Real property, which is everything that is affiliated with dirt and anything that's permanently affixed to dirt. And after that, it is personal property, which is everything else. So if you take a look at your book, so it's real property, land and things embedded in the land, such as oil tanks, include things attached to the earth, such as buildings or trees, and rights to any of these things. Personal property, as I said, is everything else, but the definition in the book is property that is movable or intangible, or rights in such things. Intellectual property belongs there. Personal property, or that. So you could read the part of the book if you like. So that's the difference between personal property and real property. Right now, we're talking about personal property. We will talk about real property in detail later, but right now we're talking about personal property. And number two on my outline is title to personal property. So title, when I use the word title, I'm not talking about a piece of paper. To those of you that own a car, you know that you get a title to your car, and it's a piece of paper. And that actually does show ownership, and that's a great thing. But when I say title, what I'm really talking about is the concept of ownership. Who actually owns the property? Okay, so title may be a piece of paper. That's what Pennsylvania and every state does as far as the motor vehicles that are in your state. But it's much more than that. It is the ownership. Okay, so one of the things that's going to happen in this particular chapter is we're going to have some old cliche sayings that we're going to talk about, and one of which is possession is 9/10 of the law. And the reality is that's pretty true. When we talk about personal property, because there's not necessarily any kind of document of title for most pieces of personal property, what you end up with is who has possession of it. Are we going to assume that whoever is in possession of the property is its owner, has title to that property? And in reality, the answer is yes. If you talk about your computer, if you talk about your couch, you talk about your backpack, or any of those types of things, the only reason that we believe that they're yours is because that they're in your possession. Okay. Now, do you have a certificate of title? Do you have a document of title? In theory, you could have a bill of sale, which would be the receipt for when you bought the various items. Close to a certificate of title. It proves that you purchased it and came into title for that property. Not necessarily show that you still are the owner, but it's pretty close. But also the reality of it is we don't carry around all of the receipts for all of the things that we bought in our life. I've got a can of Coca-Cola here. Is that my can of Coca-Cola? Do I have a receipt for it? No, gee, I went to the vending machine. The vending machine didn't give me a receipt, so I don't have any proof that Coca-Cola is mine. Well, it's in my possession, so we're going to assume that it is. Okay, so possession is a concept. Title is a different concept. But when it comes to personal property, whoever is in possession is going to be presumed to be the owner. And we're going to see that creates a problem in the commercial transaction area, where we may have people that aren't the owners that are in possession of personal property. And this next few chapters is all about how to deal with that. Okay. Title to property is acquired in different ways. Property is most commonly purchased. Purchase and sale of goods is governed by the law of sales, the UCC, which we'll talk about in a later chapter. We're going to talk about getting property by gift, finding lost property, occupation, and escheat. Ooh, love the word escheat. No title is ever acquired by theft. So if you steal something, you never achieve any kind of title. You never achieve any kind of ownership. So therefore, since you don't have ownership, you can't give good title to that piece of property. If you sell it to somebody else, they're not getting title because you don't have title. Okay, so if you sell something that is stolen to somebody else, and then later on the true owner goes after that other person, the fact that they paid you for the property doesn't mean that it's now theirs. Okay, so title can never be transferred from theft. Theft never gives you title. Okay. All right, moving forward. Let's talk about gifts. That's number 3 on the outline tonight. Gifts. We have 1, 2, 3, 4, 5, inter vivos, causa mortis, minors, conditional, and anatomical. So let's talk about gifts. An inter vivos gift. Now, I've told you before that I don't necessarily like putting a lot of Latin in the way that I practice law. I like to use the English translations of things. Every now and then I have to because it's so common in the law. So when we start talking about an inter vivos thing, inter vivos is during life, okay? Not after you die. You can make a gift after you die, but that would be through probate, through your will, those types of things. But we're talking about during your lifetime, okay? So during your lifetime, you are going to, if you wanted to give a gift to somebody, you could. It would be considered an inter vivos gift. A gift that is made between 2 living persons is an inter vivos gift. For practical purposes, such gift takes effect when the donor expresses an interest to transfer title and makes delivery subject to the right of the donee to disclaim the gift within a reasonable time. Disclaiming is a whole other issue. If you don't want the property, you can refuse the gift. It's called disclaiming. And it's a whole legal issue there that we use sometimes for planning purposes. But the reality here is that there has to be an intent that a gift be made, an intent that ownership be transferred. There has to be a delivery of the item. If it's not delivered, then the gift is incomplete. I'll give you my grandfather's pocket watch, but I never give it to you, and you ask for it. I don't give it to you. You sue me. Are you going to win? No, because it's a gift. It's not a contract. It cannot be enforced. However, if I say, I'll give you my grandfather's pocket watch, and then I give it to you, it's yours, okay? A gift is an intent to transfer ownership, delivery of the property, change in possession. I actually give you possession of the property, so you are in possession. I intend to transfer ownership to you. And the last thing, which is not necessarily listed in the book here very clearly, is there can't be any strings attached, okay? For it to be a completed gift, it has to be a no conditions attached to it. Here, I'll give you my grandfather's watch. Here you go, it's yours. That's complete. I didn't reserve any right to take it back. Okay, so if I reserved the right to take the gift back, then the gift was not complete. Ownership was not transferred, and nothing has happened. There's been no legal transfer of ownership. Okay, so that's an inter vivos gift. If the donor dies before doing what is needed to make the gift effective, the gift fails. Here, I'll give you my grandfather's watch. Come over on Saturday, I'll give it to you. On Friday, I die. The delivery was not made, so therefore the gift was not complete. If you die before I give it to you, then the gift isn't complete, okay? Whoops. The next thing that I have on the outline is gift causa mortis. Gift causa mortis is in contemplation of death. So if I am going in for a serious medical treatment, a surgery of some sort, and I don't know that I'm going to live, one of the things I can do is I can call my children together and I can start giving them my property. Here, you take this, you take this, you take this. If I don't live through the surgery tomorrow, these are all yours. So that's a gift in contemplation of death. It's a conditional gift. Because if I live, I'm taking that stuff back. Oh, that's that string I talked about, okay? So a gift causa mortis is not a completed gift until I die. If I die during the, whatever I was contemplating, then the gift becomes completed. If I don't die and I want it back, that string that I left on there, that I can pull it back to me, that keeps it from being a completed gift, okay? But it will be completed once I die. All right, the next thing is minors. can I make a gift to a minor? You know, my kids had birthdays all the way through from when they were born till before they were 18. Does that mean I can't give them anything? Because remember, minors have that problem that they are, what is it? Statutorily incapacitated because of the fact that they have the right to disclaim or to void contracts. So, can they own property? Now, when we're talking about things that are of no value, okay, here's your bicycle. Here's here's some toys. Nobody cares about it. Okay, we're talking about when we end up with gifts of great value, and sometimes this can happen. It happens in my law practice when we want to get money out of the older generation's hands, so it doesn't end up getting taxed at their death. Can they make a gift to somebody who's under 18 years of age? The answer is if it's a great value, not directly. Okay, we can't end up giving that money to a minor because the minor can't deal with it legally. Okay, they theoretically can't open up a bank account. They can't take the money out of the bank account. They can't do anything with it. So what we do is there's two versions of the law out there. There's UGMA, UGMA, Uniform Gifts to Minors Act. There's UTMA, UTMA, the Uniform Transfers to Minors Act. There's a few differences between them. Every state has adopted one or the other of those. And basically what happens is the minor ends up being the owner of the property. Let's say that it's $10,000 that the grandfather wants to gift to the grandchild. So here, grandchild, I'm going to give you $10,000. Well, you can't because he's under 18. He can't accept that gift. What would happen is we would end up going to a bank and the money would be put into an account, an UGMA or an UTMA account that would say that would be titled in the name of the grandchild. And then it would read UTMA account. And then it would list somebody as the custodian of that account. Generally, it's going to be their parent or some adult that is going to be responsible for them. Now, what happens is the adult that is the custodian, they're the ones who have the responsibility of safeguarding the money. So if they end up taking money out, it has to be used for the benefit of the minor. Otherwise, it's expected that it's going to stay in the account until the minor turns 18 or 21, depending on the rules of the state that you're in. But the child, the minor, is the owner of the property. They're just not allowed to touch it. It can only be accessed by the custodian. Okay, that's a law that has been created that will give us the ability to make gifts to minors. Because as I said, we do that on a regular basis in the estate planning world. The next thing we have out here is a conditional gift. Conditional gift, the gift may be subject to a condition. This is your car when you graduate, or this car is yours unless you drop out of school. The first example is a gift subject to a condition precedent. Oh, wait a minute. Did we talk about conditions precedent? Yes, we did. And we talked about ways of terminating contracts. The second example, the car is yours unless you drop out of school, that's a condition subsequent, right? So a condition precedent, the gift doesn't happen until the condition occurs, and then it becomes fully functional. The second one, a condition subsequent, means that the gift has been given, but it can be undone by the later event. You dropped out of school, you don't get to keep the car. Okay, that type of thing. So that's very consistent with the way that we talked about methods of terminating contracts with conditions. So make sure you remember condition precedent and condition subsequent here. All right. Final thing on my list of gifts here is anatomical gifts. Anatomical gifts are where you have the right to make a gift of parts of your body or your entire body if you so desire. Person may make gifts of parts of their bodies. In the case of kidney transplants, person may also make post-death gifts. The Uniform Anatomical Gifts Act permits persons 18 years or older to make gifts of their bodies or any part thereof. The gift takes effect on the death of the donor. So many of you may have the organ donor designation on your driver's license, that type of thing. Keep in mind at Teal, we now have a physician's assistant program. And over in the science wing, there is a cadaver room where there are people that the physician's assistants do practice their various medical treatments on the dead bodies. So that's really the only way that doctors or physician's assistants or dentists or people that are in the medical field can get practice doing certain treatments to an actual human being. So those are people who donated their entire body upon their death. Other people, it's going to be an eye, a kidney, a liver, pancreas, lungs, whatever is useful that can be transplanted into somebody who needs that particular organ. So yes, that exists. There is a law out there, the Uniform Anatomical Gifts Act. So you have that out there. So it lists under gifts. All right, now the next thing is number 4, lost property. Lost property. Now, I'm going to look at the first 2 things under number 4 together. A is mislaid property and B is lost property. Now, the book isn't very clear about this, but I want you to understand the difference between mislaid property and lost property. Let's start with mislaid property. Let's say that you are a student at Thiel College and you want to, all of a sudden you decide that you have this new hobby, you want to get into photography. And so you start taking pictures with your phone, because we all have phones with wonderful cameras in them. But you decide you want to go a bit higher than that, a little bit more in depth into this hobby. So you actually go out and buy yourself a pretty substantial digital camera, something that costs you some money. It's got all these features. It gives you the ability to take better pictures. So you're very happy with all that. Let's say that the camera came with a case, that you carry it around in a case, and it's got a strap, you wear it around your neck and you carry it everywhere you go. Let's say that you go into the bookstore, and the bookstore has a rule that you're not allowed to take packages in because they're afraid of people putting things in their bags and shoplifting. So there's a table at the front that you have to leave any kind of a bag, and they consider your camera bag to be a bag. So you leave it there on that table. The unfortunate thing is that you've gone into the bookstore shortly before they close. They're in kind of a hurry to get in and out of there. Plus, they're pressuring you because nobody wants to work past their allotted time. So closing time comes, they're pressuring you to make your purchase. You pick out what it is you want to buy. You go to the cash register, you pay for your item, and they usher you out the door, and you go back to your door. You forgot to pick up your camera. Okay, so now when you get back to your dorm, you realize you lost your camera. You don't have it anymore. You don't have possession of your camera. And that becomes a problem because, we have this possession issue. Possession is 9/10 of the law, that type of thing. This is where it actually comes into play. Because, see, the people who are going to find your camera the next day, so whoever's going to open up the bookstore, they're going to open it, the store up, and they're going to see your camera bag over there with the bag where the bags are supposed to be. They may not know whose camera it is. It may be an entirely different person that's on duty that day, so they don't know you were in yesterday. But they do know that whoever lost that camera is probably going to come back for it. Because, see, when you got back to your dorm, you realized you couldn't go back for the camera because the store was closed. There's nobody there. So you have to wait until the next day when they open the store back up so that you could go down and claim your camera. The people who found it, they realize that somebody's going to be coming back for this. See, you don't have possession of it anymore, so it's in jeopardy, right? But you know where it is. You have a very good idea where it is. So you go back the next day. Whoever found it, they are not allowed to keep it. Under this situation where it's mislaid property, where it's very likely the person who lost the property will come looking for it at the spot where it was lost, then it's mislaid property. If you find mislaid property, you are required to turn it in to whoever is in charge of that geographic area. So you found it in the bookstore, and so your requirement would be to turn it into an employee of the bookstore, more appropriately, probably the manager of the bookstore, so that they can hold it waiting for the true owner to come and claim it. And that's what's going to happen. You know, after the store's been open for a short while, you show up and say, "Hey, did I leave my camera here yesterday?" And they're going to say, "Oh, can you describe it?" You know, they're going to make sure that, you know, hopefully you have your name on it or some sort of identifying mark so that when you identify it, they'll say, "Oh yeah, this is your camera," and they'll return it to you. Okay. The person who finds mislaid property has no right to the property. Lost property. Same thing, you have your camera. But the thing you don't realize is that your camera has a zipper or a snap on the bottom of the bag, and you're walking across campus and the bag opens up and you don't realize it. And your camera just falls out of the bag somewhere on campus. You don't know. You have no idea. With the other situation, you knew it was at the bookstore. With this, it's somewhere on campus. Is it in one of the buildings? Is it in one of the classrooms? Is it in the grass on the commons? You don't know. This is lost property. Okay, since we don't have a person in charge, and since there's not an expectation that you're really going to know where this is, the finder of truly lost property, acquires a portion of title. They never get full title because, well, let's put it this way. Whoever is in possession of lost property has superior title to everyone in the world with the exception of the true owner. Okay, so if you found that camera, it would be yours to keep unless the true owner found out that you had it and demanded its return. You would have no obligation to turn it over to anyone else. You would have no obligation to turn it over to campus security. You would have no obligation to turn it over to the registrar's office. You know, there's no requirement. Okay, that's the difference between mislaid and lost. You have superior title to everybody except the true owner. Next, abandoned property. You might be asking, who would abandon their property? I do it all the time. You do it all the time. Everybody does it. We all abandon property. As I'm taping this, it's Monday night, and here at my house, Monday night is the night that I take the garbage down to the curb. So at some point this evening, I'm going to package up everything that I no longer want, the spoiled food, the wrappers, the recycling, and I'm going to carry it down to the curb because early tomorrow morning, the township is going to come by and they're going to collect the refuse. Okay, I'm abandoning that property. When I take it to the street, I'm telling the world, I don't want this anymore. I'm giving up my ownership. Now, it's not a big deal because who's going to want my trash, right? But let's just say that, you know, another one of the things that I'll do is I'll take items that are not trash, but I just don't want them anymore. Say I have an old bicycle that I don't want to use anymore. I'm not the type of person that's going to put the time into trying to sell an old piece of property. I just want to get rid of it. Now, if I take it down to the curb, it might get picked up by the refuse, the township refuse people, right? Or in my neighborhood, you know, I live in a relatively nice neighborhood. There are people that they know what day trash night is, and they will go out through the night and they will look at what's in front of everybody's house. So if I have this bicycle out in front of my house and one of these people drives by and goes, "Oh, wait a minute, there's a bicycle over there." And they go and they look at it and they decide that they would like to take the bicycle, and they take it and put it in their car and they drive away. They now own that bicycle. Okay, because when I put it out in front of my house, I indicated to the world that I was abandoning that property. I no longer wanted to have any ownership of it. I was trying to get rid of it. So who's going to end up with title to that property? Whoever it is that takes possession of it next. Okay, now I'll be very honest with you. I would prefer that somebody come and take that property because I don't want to really see it go into the landfill. So when one of these people comes along, whether they're going to sell it for scrap, you know, they'll take it to a junkyard where they're going to get money for it. It'll be melted down and turned into something else, recycled, or whether they're going to take it home and fix it up a little bit and then try and sell it to somebody and make a few bucks on it. Great. I want that to happen. I'd rather that happen than it go into the landfill. And they're allowed to do that because once I abandoned it, if they took possession, they're now the owners. Okay. Then the last thing we have under lost property is wild animals. Let's talk about wild animals for a minute. Wild animals living in a state of nature are not owned by any individual. In the absence of restrictions imposed by game laws, the person who acquires dominion and control over a wild animal becomes its owner. What constitutes sufficient dominion and control varies with the nature of the animal and circumstances. It's a deer and it's deer season, and you shoot and kill the deer as part of your deer hunting experience. Did you just exhibit dominion and control over that deer? Yes, you did. So wild animals can become property if you exhibit dominion and control. If you trapped it and you didn't kill it and you took it, I guess that's also dominion and control, so you would be the owner. If an animal is killed, tied, imprisoned, or otherwise prevented from going about its will, a hunter exercises sufficient dominion and control over the animal and becomes its owner. If the wild animal subsequent to its capture should escape and return to nature, it returns to its status of a wild animal. Okay, so there's the rules as to your deers and deer hunting. Okay. All right, now the next thing that I have on my outline here is the tort of conversion. So we talked about a lot of different torts, right? We talked about the intentional torts, battery, assault, intentional infliction of emotional distress, false imprisonment. We talked about negligence. That's a huge tort that gets you into court quite often. We talked about strict liability, which is another way that you can use, another thing that you can use in order to get into court to try and sue somebody. We also have this one called conversion. And conversion is a very old tort. This actually comes out of common law. It's comes out of Old England. The tort of conversion has its origins in the ancient common law writ of trover, created as a remedy against the finder of lost goods who refuses to return them. Because of that origin, the tort of conversion was limited to property that could be lost and found. Nowadays, it's a little bit different. I want to see what the book has to say about it. Oh, I gotta go back a page. Common law courts expanded the tort of conversion to include documents with its definitional scope, despite the intangible assets, which invariably are primarily components of the value. The concept of conversion today, which is the wrongful exclusionary retention of an owner's physical property. So there's your definition. There's the definition of conversion. The wrongful exclusionary retention of an owner's physical property. So now, getting back to title and possession and all that, this is a situation where somebody else has possession of property that is yours. So, for example, if I were to lend my lawnmower to my neighbor because his lawnmower was broken, and he asked if he could borrow my lawnmower, and I said, sure. And he takes my lawnmower and he mows his lawn, and then he puts the lawnmower in his garage. And then I say to my neighbor, hey, can I have my lawnmower back? And he says, no, I'm not going to give it back to you. My mower is broken and I need to be able to mow it. You have to understand, my neighbor, he mows his lawn like every other day. He's very obsessed with his lawn. So if he did not have a lawnmower, it would probably kill him. So no, I'm not going to give you back the lawnmower. It's going to take me a while to replace mine. So I'm just not going to give you yours back. Is that wrongful? What is the definition here? Wrongful exclusionary retention of an owner's physical property. Yeah, it's my property. I'm the owner. He has possession of it, originally with my permission. I've asked for it back, and he is refusing to give it back to me. That's the tort of conversion. He didn't steal it from me because I had given it to him willingly at the beginning, but he's refusing to return it. So conversion means he's refusing to give me back my property. So therefore, I can sue him for conversion. Oh, by the way, that camera that you found, the true owner comes by and says, "Hey, wait a minute, that's my camera. I need that back." And you go, "No, I found it. It's mine." Another little saying: "Finders keepers, losers weepers." Nope, you can't have it. So the failure to return the camera would be you'd be subject to being sued for conversion. All right, so that's the tort of conversion. The next thing that we have is what's called escheat. And as you can tell from the word, escheat is not something that sounds like a word that we would use today. So escheat is the issue of unclaimed property. It originally belonged to somebody, but whoever the true owner is not trying to have possession and control of that property. The most common time you're going to see us cheat now is with bank accounts, because the government doesn't want bank accounts to sit dormant for any length of time. They want the money to be constantly churning in the economy. Okay, so if you put money into a bank account and then you don't touch that money, you don't do anything with that bank account for a number of years, the bank is going to consider that account to be stale. That means nobody has done anything with the account for a certain period of time. I don't remember what the exact periods of time are: 3 years, 5 years, 7 years. I don't remember. But once the bank declares that the account is stale, then a certain period of time after that goes by, a year or two, and they're supposed to notify you that the account has gone stale, and that if you don't do something with it, they will then take the money away from you. And that's where everything gets interesting. Escheat means that they are required by law to give that property to the government. In Old England, where this comes from, what would happen is the money would be given to the king. Okay. We don't have a king, but we do have a federal government. We have a state government. This is a state thing right now. So if your bank account goes stale and then the appropriate amount of time goes by, the bank is going to be required to send that money to the state. Escheat, E-S-C-H-E-A-T, escheat. So that means that the money is still yours, by the way. All you have to do is go and contact the state and say, "Hey, I want my money back." They'll make you prove that it's your money and that you're who you say you are, but then they'll give you your money back. Bad thing. So don't think this is a good thing that the state is holding your money, because one of the things that'll happen is they're not going to do anything towards making it profitable or making it make money for you. So there have been times where people had accounts with brokerage companies that had stock in them, and then they didn't do anything with the accounts for many years, and then the brokerage company was required to escheat those accounts to the state. So let's say you had purchased some Microsoft way back when, and you left it in this account, and then it got escheated to Pennsylvania. Pennsylvania is not holding your Microsoft. Pennsylvania only wants to hold cash. They don't want to have vaults holding personal property. So they will sell your asset and then turn it into cash. So whatever the Microsoft was worth at the time that it was escheated to Pennsylvania, that's what you'll get, the money that it was worth. The stock that they sold may have doubled, tripled, quadrupled in price since then, but you don't get any of that. All you get back was the value of the property when it was escheated to the state. Okay, so understand that it's not necessarily a good thing. You can get your money back, but it's not necessarily a good thing. All right. On the outline, it says escheat is a governmental program with its roots in old common law. Number 7, multiple owners of property. Okay, this is going to be interesting. Can more than one person own a piece of property at the same time? The answer is yes. We can have multiple owners of the same piece of property. This becomes more evident when we talk about real estate later on in the course. But right now we'll talk about, let's use bank accounts for an example, because this happens quite often in a bank account. There are, according to the book, 4 different ways of owning things with multiple parties. There's tenancy in common, which we will refer to as TIC, tenants in common. There's joint tenancy, which is actually called WR. JTWROS, joint tenancy with right of survivorship. We all just JTWROS. There's tenancy by the entireties, which we call tenancy by the entireties, and then there's community property. I don't pretend to be an expert at community property. That's a concept that is mostly founded or found in Western states. Up over here in the East, we don't really deal with community property much at all. Excuse me. So read what you want about community property in the book. I'm not going to test you on it. Understand it is a type of co-ownership of property, but usually found in Western states. I do want to talk about tenants in common, joint tenancy, and tenancy by the entireties, because those are all very important. So we can have tenancy in common. Book, tenancy in common, a form of ownership by two or more persons. The interests of a tenant in common may be transferred or inherited, in which case the taker becomes the tenant in common with the others. So if I own a hunting cabin with my brother as tenants in common, can I sell my half interest in the property to somebody else? Yes, I can. Can my brother complain about that? No, he can't. If I don't sell, let's say that my brother and I both own this, this hunting cabin, and I die. What happens to my share, my half? Well, it goes into my estate. Okay, so if I die with it, it goes into my estate. And then my heirs will eventually be the owners once my estate is administered. And so whoever in my family would end up with that half interest in the hunting cabin would be owners with my brother. Okay. Can my half interest be taken by creditors? Yes, it can. What else? Let's go away from that now. Let's talk about joint tenancy. Okay, joint tenancy with right of survivorship. Survivorship is right in the title. What that means is that if my brother and I own this cabin and I died, if we owned it as joint tenants with right of survivorship, what would happen is on my death, my half interest would go to the other owner. Okay, so I own half as a joint tenant. My brother owns half as a joint tenant. I die. My brother now gets my half by operation of the title. Doesn't have anything to do with wills. It doesn't have anything to do with probate law. The title describes who is going to be the owner if somebody dies. Okay, so joint tenants, it's not an inheritable thing. Tenants in common, yes, if I die, it goes into my estate. My heirs will take it. Joint tenancy, if I die, it goes to the other owners. It can be as many as you want. It doesn't have to be just two. Let's say there's 4 of us that are joint owners of this hunting cabin. If I die, then my interest is sort of extinguished, and the other 3 owners, instead of owning a quarter each, would now own a third. Okay, so my share I think it's easier to look at it as being extinguished, but it just would go to the other owners. Can I sell my interest in a jointly held property? Yes, I can. But the thing here is that if I sell my half interest of the hunting cabin to somebody else, I can do that. But is my brother required to be a joint tenant with that person he doesn't know? Now, he's okay with me being a joint tenant because if he dies and I end up with it, it stays in the family. If I sell my part of the property to somebody outside of the family, he's not going to want his share to end up going to that stranger when he dies. So what happens with the joint tenancy, yes, you can sell your share to an unrelated third party, but if I do, it destroys the joint tenancy. It converts the joint tenancy into a tenancy in common, TIC. And then what happens is my brother's share, if he should die, doesn't go to the other co-owner, it would go to his estate. Okay, these are all rules because they make a lot of sense if you think about what people would want to do in these circumstances. All right, can a creditor take away your share of joint tenancy property? Yes. All right, the last one is tenancy by the entireties. The big thing about tenancy by the entireties is you can only have 2 people in this as co-ownership because this is ownership by a marriage. Now, in today's world where we have same-sex marriages as being considered legal, this applies to same-sex marriages. It's just going to be easier for me to use the more classic husband-wife situation here to talk about this. Okay, so husband and wife are married, they obtain some property, and they do it as joint tenancy by the, tenants by the entireties. What that means is the two of them are the owners. Now, the big thing about this is we don't treat either the husband or the wife as being the owner. We treat the marriage as being the owner. So, can the husband sell his half share without the agreement of his wife, the other tenants by the entireties? No. You cannot destroy a tenancy by the entireties by one party. Can they sell the thing together? Yes, but they would have to do it together. Okay, so it would be the marriage that's doing the sale, not the husband, not the wife. Okay, so if both of them combined, they could indeed sell the interest in the property. Can it be taken by a creditor? If it's a creditor of both the husband and the wife, yes. If it's a creditor of the husband alone or the wife alone, no. And this is a big deal because this is a big planning opportunity. So if you have, say, high wealth, high risk people as clients of yours, you want them to own things as tenants by the entireties. A doctor, he can be sued for malpractice. Oh, the big thing is, am I going to lose my house? Well, if he gets sued for malpractice and it's a massive, massive judgment against him, it's a judgment against him. It doesn't go against the property because it would have to be both the husband and wife doing the transfer. So a creditor of one of the two cannot attach or take the property. Once again, this is a tremendous planning opportunity. What was the other thing? What happens when one dies? Well, then the other, it acts very much like a joint tenancy. If the husband dies, the wife becomes the whole 100% owner of the property. The wife dies, the husband becomes the 100% sole owner of the property. Okay, so there are reasons why you would want to have some things as tenants in common. Like I said, it's not a married couple situation, and you want it to be an inheritable interest. Fine. There's a reason to have it as joint tenants with right of survivorship because you want it to go to the other owner. Say this hunting cabin was my parents, my father's, and he left it to his two sons. So ultimately, we don't want it to go outside of the family. So owning it as joint tenants certainly makes it appear, okay, it's going to stay in the family. It's going to go to the other person when the one person dies. There are reasons why you want to do these things. And there are certainly planning opportunities to use tenancy by the entireties if you have a marriage involved. It's a big thing. It's a good thing. Okay, moving right along. The next thing that I have on the outline is bailment. All right. This is where we're going to have, for usually business purposes, we're going to have possession of the personal property not be with the true owner. Let's say, for example, I need to rent a truck from U-Haul. Okay, who's the owner of the truck? U-Haul, the company is. Who's going to be in possession of the truck? Me. Okay, so I'm not the owner, but I'm going to be in possession of the property. U-Haul is the owner, but they don't have possession. This is what's called a bailment, B-A-I-L-M-E-N-T, bailment. This is where the owner of the property will give it to somebody else, give possession to somebody else, and that person has the ability to possess it, but they will not own it. Okay, now, there's three different types of bailment. Let's see what the book talks about here. A bailment is a relationship that arises when one person delivers possession of personal property to another under an agreement, express or implied, by which the latter is under a duty to return the property or to deliver it or dispose of it as agreed. The person who turns over possession is the bailor. The person who accepts possession is the bailee. There are many forms of bailment in our society. They give you a list of examples here that are kind of off the wall. Case you can read if you like. Okay, elements of a bailment. A bailment is created when the following elements are present. Agreement. The bailment is based on an agreement. The agreement may be expressed or implied, generally contains all of the elements of the contract. The bailment transaction, in fact, consists of 1, a contract to bail the property, and 2, the actual bailing of the property. Ordinarily, there's no requirement that the contract be in writing. The subject of the bailment may be any personal property of which possession may be given. Real property cannot be put into bailment. You can't do real property. It's only for personal property. All right. Delivery and acceptance. The bailment arises when pursuant to the agreement, the property is delivered to the bailee and accepted by the bailee, subject to the bailment terms. All right. So now we have to look at who is benefiting here. Is it the bailor, the person who's giving up possession? Is it the bailee, the person who's receiving possession? Or is there mutual benefit where both parties benefit from this agreement? All right, so we have 3 different types. Bailment for the benefit of bailor, benefit of bailee, and benefit for mutual benefit. Pretty much what I just said. So that being said, continuing along. Benefit of the bailor. Okay, the person, it's for the benefit of the person who's giving up possession. Let's see if the book has anything, because I've got my own, but I'm just curious what the book has. It just talks about it. I'll give you an example. Let's say I'm going away on vacation. I'm going to be away for 3 weeks, and I'm concerned. I actually live in a nice neighborhood. I wouldn't be concerned, but let's just say that I live in a neighborhood where I'd be concerned that if I left my car sitting in my driveway for the 3 weeks that I'm going to be gone, that it might be a bad thing. So what I want to do is I want to have my car in a garage somewhere. I have a neighbor that next door to me who were friends, and I go to him and I ask him, say, hey, John, would it be okay if I were to park my car in your garage for the next 3 weeks while I'm away on vacation? Would you mind if I did that? And being a good friend, he would say, well, that's fine. I have no problem with that. Let's do that. So I take my car over and I pull it into his garage. I'll leave the keys with him in case he needs to move it. And then I go away on my vacation. What benefit did my neighbor get from this bailment? None. What benefit did I get from the bailment? Well, now my car is secured and safe. So did I receive a benefit? Yes. That is a bailment to benefit the bailor. You're going to see why this is important in a minute. I'll give you an example of a bailment for the benefit of a bailee. Same neighbor. This is the guy that likes to cut his lawn, and he asks if he can borrow my lawnmower. And I say, sure, no problem, John. Just, bring it back when you're done. So I give him my lawnmower, and he goes and he cuts his lawn. Now, is this a bailment? Yes, it is. Why? Because there is an agreement to change possession of personal property. Okay, no title change, no ownership change, just the title, just possession. So I gave it to him because his lawnmower is broken and he was able to cut his lawn. Did I get any benefit out of that? No. Did he get a benefit out of it? Yes, he was able to use my lawnmower. If he wanted to cut his lawn, he would have had to either gone and bought a lawnmower or rented a lawnmower or hired somebody to come and do his lawn for him. So that was a benefit, a bailment for the benefit of the bailee. Okay. Mutual benefit. A bailment for mutual benefit. As I said before, let's say I need to move something, so I go to U-Haul and I rent a truck. So I go there and we sign the paperwork and they give me the keys to the truck and I pay them for the privilege of using their vehicle. Okay, so did I receive a benefit? First off, I'm the bailee here, right? Because I'm receiving the property that is not mine. I don't own it. I'm going to get possession, right? So I get possession of the truck. Did I receive a benefit? Yeah, I get the truck. I get to use the truck. Did U-Haul, the bailor, did they get a benefit? Yes, they did. They received money in exchange for getting into this bailment contract. This is a bailment for mutual benefit. Why do we care? Well, we care because um, we now have to talk about the duty of care that has to be exercised by the person who is in possession of the property. Okay, the bailee has a differing level of responsibility to protect and maintain the property. Let's see if the book talks about it, or if I'm just going to keep going off the top of my head. Hold on here. A breach of duty of care. Well, I'll just talk about it. If we have a bailment for the benefit of the bailor, I'm giving up possession and I'm the only one that's getting the benefit. I'm putting my car over in my neighbor's garage while I'm gone on vacation. He's not getting anything out of this. Should he be held to a very high level of care to take care of my vehicle? Or should his level of care be relatively small? Reality is I think his level of care should be relatively small because he's not getting out of this. He's basically getting anything out of this. He's basically doing me a favor. So there you go. Is he allowed to, to destroy my vehicle? Is he allowed to be careless with it? Is he allowed to, he was mowing his lawn and he scratched the heck out of the paint job because he wasn't being careful? No. How about a reasonable level of care? But it certainly isn't going to rise up to any massive significant level of care. Okay, it's going to be a minor level of care. He just has to be reasonable about how he's going to do that. What about if it's to the benefit of the bailee? So I'm going to lend my neighbor my lawnmower. So while he's using my lawnmower, he forgets that there's a small rock in the middle of his lawn, and he has the mower set too low, and the blades hit the rock repeatedly, and to the point where it breaks the lawnmower. Okay, so my neighbor then brings me back my broken lawnmower. Think that's appropriate? No. That his level of care should be heightened because I, as the bailor, got no benefit from lending him my lawnmower. He's going to have a heightened level of responsibility or duty of care because he's the one who got the benefit, not me. So he's certainly going to have to return the mower to me in its appropriate, proper, basically the way I lent it to him. It doesn't have to come back better, but it can't come back with any kind of damage. He has to make sure that it comes back pristine the way I gave it to him. Okay. Mutual benefit is going to be that basically we're going to use common sense, the reasonable man, I guess. Both U-Haul and I have to exhibit a certain level of care. I've got to give them back their truck in the condition in which it was given to me. They're going to have to make sure that the thing actually runs while I'm using it. So if it breaks down, they have a duty to fix it or replace it so that I get the benefit of my bargain, of my agreement of getting into the bailment of renting the vehicle. Okay, so the type of bailment will determine the level of care required by the bailee, person in possession. Okay. All right, now let's see. Oh, I got a couple of other things. I have on number 9 here, I have concept of possession of personal property. Let's see what the book has to say here. Okay, so this isn't anything that's necessarily in the book. This is my personal beliefs and thoughts on this. So number 9 is concept of possession of personal property. Number 10 is concept of title to personal property. Let's start with title. Title Most of the time, you're not going to have a document of title. With a car, yes, you do. Oh, I've got this thing that actually says title on the top of it, and it's issued by the state that says I am the owner of this motor vehicle. That's because the state is concerned with people stealing vehicles and selling stolen vehicles. So they create this title situation so that it's harder for somebody to steal a car or to sell a stolen car. You have to have the title in order to have that right to sell the property, right? But with most things, there's not a title. I don't have a title to my lawnmower. I don't have a title to my bird bath. I don't have a title to my computer. I don't have a title to my furniture. I don't have a title to most of the things that I own. Okay. But I'm the owner. How do you know I'm the owner? Mostly because I'm in possession of it. Okay. So understand that our belief, our standard, our given, if you will, is that the owner is generally in possession of the personal property that he owns. Now, we understand that that's not always the case. There is always a chance that it's for business reasons, somebody else may be in possession of your property. The next few chapters are going to be about how we deal with it when somebody else, for purposes of commerce, most specifically, has possession of somebody else's property. Possession is 9/10 of the law. If you don't have possession, it's usually hard for you to prove that it's yours. Hey, that's my calculator. Is it? Prove it. Well, I can't. My friends know I have a calculator like that, but yeah, there's hundreds of these, thousands of these have been sold. How do you know this is yours? I can't prove it. Well, it's mine. I bought this. You can't prove I didn't. Possession is going to give you a presumption of ownership. You may not be the owner. You may not have any legal rights to it at all. But we usually assume that you're the owner because you're in possession. Okay. Possession is important. If you give up possession of your personal property, you probably should have some sort of a writing proving that the property is yours and it's just in the other person's possession. Okay. That's why U-Haul, if you go to U-Haul and rent a truck, you're going to have a contract, an agreement, a rental agreement between you and U-Haul. If you get pulled over by the police for some sort of a traffic violation, you have to prove that you had the right to possession of that property. Otherwise, you could be theoretically hauled off for grand theft auto truck, I guess. So understand that possession most of the time means title. Not always, and we're going to talk about the times when that is not the case. All right, that's all I have on chapter 20. Possession, personal property, possession, bailment. We talked about a whole bunch of stuff. Just real quick, take a look at the outline that I provided for chapter 20. Now, we talked about personal property versus real property, title to personal property, who owns it. We talked about gifts and how you can obtain ownership or title through a gifting process. We talked about what happens with lost property, mislaid, lost, abandoned. We talked about wild animals. I'm not going to test you on wild animals. Conversion is failure to return property to its rightful owner. I can sue you for that. The interesting thing about that is the damages that the court would award would be the cost to replace the item. Wouldn't be, oh, I paid $1,000 for that, but it's 10 years old, and so there's a lot of depreciation. It's really only worth $500 now. Conversion, if it's cost you $1,000 10 years ago, it probably cost you $2,000 to replace it today. That's what you would get. Okay, so conversion is kind of a nice one. People like to sue in conversion if they can. We talked about a escheat. That's where you give the government money for assets that have been theoretically abandoned. Talked about multiple ownership of property, tenants in common, TIC, joint tenants with right of survivorship, JTWROS. We talked about tenants by the entireties, which is for married couples. Understand the differences, the legal differences between those three types. We talked about bailment. We have bailor, the bailee. We talk about the benefit of bailor, benefit of bailee, and mutual benefits. And then just make sure that you understand how important possession is when we talk about ownership or title to personal property. All right, that's all I have for today. I'll see you next class.